Good evening, everyone. Welcome to the LSLC's first event of 2026. Apologies, those of you who were expecting to see Vasanthi Selvaratnam here. She has not been able to attend because she's abroad, but I'm sure she's online and with us there. It falls on me as one of the representatives of one of the sponsors tonight, 36 Stone, to welcome you all here. Thank you also to Stewards for their generous sponsorship of this event. Now, the London Shipping Law Centre is lucky to be able to attract new as well as previous speakers. And this evening, we have 3 people who are speaking for the first time at an LSLC event, which I think is pretty unique. So a very warm welcome to everybody. I'm not going to say that much by way of introduction, because that would be stealing Rachael's thunder, who's going to be chairing tonight's event. But let me say a couple. Has the intriguing title of Risk and Funding Partner at Stewards. It struck me that that's the kind of thing James Bond might have on his business card, so I'm sure we're really in for a treat from him. Hassan Azizagaglu assures me that he is in the unique position of being a funder with a PhD in maritime. So really an eminently qualified speaker for our topic today. Mulheron, my colleague from 36 Stone, is probably someone who is known to all of you. Mo joined us after spending some years in private practice in solicitors' firms, so really has a pretty unique take on some of the issues which we're going to be discussing today. And finally, back to our chair. A little about Rachael, for those of you who do not know. Rachael is a professor of tort law and civil justice at the School of Law at Queen Mary University. Over 20 years, I discovered when reading from the profile today. Amongst her many areas of interest, civil procedure and funding in particular, which is, of course, our topic for tonight, feature very heavily. In 2023, Oxford University Press published her most recent book, The Doctrine or Modern Doctrines of Champity and Maintenance, which, as some of you will know from reading the early cases, still can crop up and give rise to knotty problems in this area. I can think of few people so well qualified to lead our discussion on third-party funding in international commercial arbitration and litigation. And so with those introductory words and welcome, Rachael, over to you.
Thank you. And thank you, Ravi, for that warm introduction. And good evening, ladies and gentlemen. And a very warm welcome to this seminar this evening on the subject of third-party funding in international commercial arbitration and litigation online as well. We hope that you find it of interest. Third-party funding remains a hot topic, courtesy of a number of features. And just to mention 3 of those very briefly. First of all, the Civil Justice Council published its report, a review of litigation funding, ongoing concerns surrounding the potential reversal of PACCAR, and the fact that this was flagged by the government with the intent to reverse it, courtesy of a ministerial statement by Minister Sarah Sackman on the 17th of December. And thirdly, third-party funding remains really crucial, indeed sometimes the only way of bringing these large cases in the business and property courts and in the Competition Appeal Tribunal, for example. It is also worth pausing to remember that last year was the 20th anniversary of the decision in Arkin, and what a decision that ended up being with respect to protection of adverse costs for funders, but perhaps not being applied with quite the same assiduous enthusiasm as it was met with back in the 2000s. So these and all topics will be featured in the panel's discussions this evening. And it's a very distinguished panel, which it is my great pleasure to introduce to you. Our first panelist will be Mulheron, a barrister at 36 Stone. To reiterate, Mulheron has extensive experience of international commercial litigation and arbitration, and prior to joining 36 Stone, he worked as an employed barrister for many years at the world-leading dispute practices of Gibson, Dunn and King and Spalding, acting on behalf of some of the biggest companies in the world. He has extensive experience of multi-jurisdictional litigious disputes and of investment treaty arbitrations. He also practices in the areas of shipping law, international trade, and commodities disputes. Our second panelist is Dr. Hassan Tahsin Azizaglu. Hassan works as a portfolio manager at Bench Advisors, where he oversees he has extensive experience of negotiating funding agreements and of enforcement proceedings, amongst many other aspects of funding. He has been involved in investment and commercial arbitrations, class actions and collective proceedings, and cross-border litigation across multiple jurisdictions. And as mentioned, and I emphasize again, to assist with the intricacies of this work, Hassan also holds a PhD in private international law. Our third panellist is Julian Chamberlain, who is the risk and funding partner at Stewart's. Julian heads the costs and funding disputes team, and in that capacity, he advises clients in relation to costs, insurance, and funding across high-value and complex litigation. Under Julian's stewardship, Stewart's has developed the Stewart's Litigate Insurance Facility with A.J. Gallagher. Julian also chairs the Stewart's Risk and Funding Committee, which reviews and approves funding arrangements across all of Stewart's practice areas, including the use of CFAs, DBAs, pre-issue contingency agreements, ATE, and third-party funding panel, which is assembled here this evening. The format of the seminar is that each have 20 minutes each, and at the end of their presentations, fellow panelists will chip in with any observations or feedback that they may wish to make. And then at the end of the three presentations, there will be time for Q&A and feedback from the audience. And I shall draw those of you here and those online in to that section at the end for the last 20 minutes or so. So without further ado, I hand the floor to Moise, who will take us through some of the historical aspects of funding and how this has influenced where the industry is today. Thank you, Moise.
Thank you, Rachel, and thank you everyone attending in person online, and thank you to co-panelists. As Rachel said, I'm going to be something's gone wrong with the cover page. Some of the historic background discussed by my co-panelists, really trotting through where we've started and where we've been and where we are now before the issue troubling. So if I begin with that introduction, I want to start with the topic of definitions, because they can be ambiguous in this context. Third party mean different things. So to be clear what we're talking about, what I'm talking about, by third party funding, litigation funding, interchangeable. What I mean is the provision of financial by a third party that has no, so on the basis that if they receive nothing if the action fails, but a share of the proceeds recovered if the action. So there's two really key points to bear in. Is that better? Is that better? Even closer? There we go. So there's really two key points to pick up from that definition. One, third-party funding involves funding by a party with no interest in the dispute, as opposed to funding by a party's own legal representative. And I'll talk briefly about CFAs and DBAs in that regard shortly. And second, the remuneration of a third-party funder is based on a share of proceeds if the action succeeds. So there's a distinction that I draw, and I think has been drawn in the recent literature as well, particularly the Civil Justice Council's report of last year. I know Rachael and Julian are both involved in preparing that and in the consultation for that. So they may talk about it in more detail, but there's a distinction between litigation financing and on the one hand and contingency fee financing on the other. I'm not going to say very much about CFAs and DBAs. They're fairly well understood. CFAs, obviously, remuneration of the lawyers based on a uplift to the normal hourly charges. They would usually charge a base fee and a success fee. And DBAs are lawyers remunerated based on usually a percentage of the damages awarded. They will become relevant, particularly DBAs, when we come to talk about PACCAR, but that's just a brief introduction now. So where does the historic hostility to third-party funding come from? As a matter of common law, it comes from the doctrines of maintenance and champity, originally crimes and torts until the passage of the 1967 Act. But importantly, as you'll see on the slide, Section 14, subsection 2 of the 1967 Act preserves the effect of maintenance and champity on contracts. So as you'll see, it says the abolition of criminal and civil liability, that's liability and tort, shall not affect any rule of that law as to the cases in which a contract is to be treated as contrary to public policy or otherwise illegal. Why is that important? It means that contracts that offend against maintenance and champity can still be considered unenforceable as a matter of English law. Interestingly, Chitty deals with these doctrines under the heading of contracts that are illegal because they have an object injurious to the proper workings of justice. So that's how these doctrines are seen, and that's how they fit into what we're talking about today. What are the rationales for maintenance and champity? First, the idea that outside interference in litigation is morally reprehensible. You shouldn't be interfering in litigation you have nothing to do with. And second, that it's somehow injurious to the proper working of justice. And we see that spelt out fairly clearly by Lord Mustill in the seminal case of Giles and Thompson, which is on the slide. I won't read it out, but you'll see he makes the point. These are crimes and torts of a medieval origin, and they really arose out of concern that the courts were not robust enough in their processes to essentially prevent trafficking in litigation. There was a concern that witnesses would be suborned, that false claims would succeed, that funded parties would suppress evidence so that their claims would succeed. There's a real concern about the court's ability to resist that, and you'll see in the final sentence that he refers to maintenance and champity as providing an invaluable external discipline to which, as the records show, recourse was often required. Now, and I think, sorry, I lost the slides on my screen. That's why I've stopped. Now, the attitudes have changed. In this quote in particular, Lord Mustall goes on to talk about the fact that courts have become much more robust in protecting their processes. They have tools such as adverse cost orders to protect their processes against frivolous claims or abuses of process that are perpetrated by funded parties. And we've seen that borne out in the cases. I'm going to trot through some of them, but we start seeing that Wallersteiner, I mean, there's a number of these cases, all which essentially make the same point, which is that what constitutes maintenance or champity, and bearing in mind that both of those doctrines refer to essentially intermeddling in litigation without just excuse, that what constitutes just excuse for those purposes has changed over time. So Wallersteiner, as you see, Lord Justice Scarman, the maintenance of other people's litigation is no longer regarded as a mischief. Trade unions, trade protection societies, insurance companies, and so on, they all do it on a day-to-day basis. A great volume of litigation is maintained by persons who are not parties to it. And similar effect, albeit almost just over 20 years later, tie trading. In examining the present scope of the doctrine, it must be remembered that public policy is not static. In recent times, the roles of maintenance and champity have been progressively redefined. Now, it's worth bearing in mind, even at this stage, that both of these decisions are quite limited in scope insofar as what they actually decide. Wallersteiner was a case about fee basis, and despite what Lord Justice Scarman says there, a majority of the Court of Appeal decided that it wasn't. It would be champitous for a solicitor to act on a contingency fee basis. It was said that rule was needed in order to preserve the honor and honesty of the profession. So you can see professional conduct concerns coming through. To similar effect, Ty Taylor was about a contingency fee agreement. Things moved on by 1998, but even then, the Court of Appeal was at pains to say that the contingency fee agreement was only lawful on the basis that the lawyer would be remunerated his ordinary profit costs. So again, a suggestion that no uplift was permissible at that stage. So we see in both of these cases a change in attitude, a recognition that what constitutes maintenance and champity is changing, but equally that there are concerns, particularly in the context of what I described as contingency fee agreements to begin with, is where lawyers' professional duties are implicated. There's a number of other cases there. I'm not going to read them all out. The salient points are by the time the courts have dealt with this in the mid-2000s in Gulf Azov, Arkin, which Rachael mentioned and Julian is going to talk a bit more about. And then we have, obviously, Lord Justice Jackson's reports in 2009, and then more recently in Excalibur. We have a judicial understanding that litigation funding is an accepted and judicially sanctioned activity. It's perceived to be in the public interest, and that's because there's a general recognition that it promotes the public policy of access to justice. It allows people to pursue claims and access funds in circumstances where they wouldn't otherwise be able to pursue litigation. Again, I'm not going to spend a huge amount of time on this, just to make the point that despite what has been previously recommended as far back as 2007 by the Civil Justice Council, the predominance of the government is third-party funding is self-regulated. So the Association of Litigation Funders within 2000, and they administer the Code of Conduct for litigation funders, the most recent iteration of which is from 2018. And there's a quote on the slide there from Lord Keane in answer to a written parliamentary question was the case had not been made out for moving away from a position of voluntary regulation. So what is the continued relevance of maintenance and champity? I think it's fair to say from the cases that we've been through, and I'll invite you to look at them in more detail in your own time. The slides will be available. But I think the salient point is that agreements with litigation funders will not per se fall foul of the rules on maintenance and champerty. That's not to say individual agreements might not still cross the line. They have to be assessed on a case-by-case basis. And you'll see the reference in Arkin in the third bullet point to the possibility that funding agreements might still fall foul of the policy considerations that render an agreement champertus. Now, there isn't a huge amount of guidance in the case law as to what that might involve, but I think it's fair to say that agreements which might cross the line are likely to include those which don't leave the funded party as the party primarily interested in the result of litigation. So if there's a very large uplift or percentage of them exercising an unreasonable level of control over the litigation. I'll canter very quickly through the rest because I am short of time. PACCAR, I'm going to spend actually very little time talking about because much ink has been spilt on this topic, and I'm sure you've heard a lot about it. Again, the relevant point is that following the majority's decision in PACCAR, third-party funding agreements, at least where remuneration is based on a share of damages, constitute damage-based agreements for the purposes of the statute and the regulation. Why is that important? Because at the time of PACCAR, at least, most litigation funding agreements didn't comply with the DBA regulations. So they were unenforceable as a matter of statute. And even if they did comply with the DBA regulations, one of the contexts where they're used most often, or their utility is recognized most often, is in the context of opt-out collective proceedings in the Competition Appeal Tribunal. And in that context, they weren't permitted at all. And I'm not going to read that out, but that's a paragraph from Lady Rose's dissent in the Supreme Court decision, quoting the then chair of the Association of Litigation Funders talking about the implications of the PACCAR decision. The relevant point on this slide is the third bullet point. There has been some success in getting around PACCAR in revising extant litigation funding agreements so that the remuneration basis is based on a multiple of the amount of costs that have been funded rather than as a percentage of the proceeds. That's been recognized as valid by the Court of Appeal as recently as last year. So there is some judicial recognition of the difficulty that PACCAR has put funders in. And just to wrap up finally, attempts at reform. Rachael mentioned some of this, but I'll just go through it very quickly. Almost immediately after PACCAR, there was a proposed amendment to the digital would have reversed the ban on damage-based agreements with funders in opt-out collective proceedings, but it would still have required compliance with the DBA regulation. So it didn't really address the issue, which was the fact that most agreements at that time didn't comply with this regulation. That's now been pulled. The Lord Chancellor asked the Civil Justice Council in spring of 2024 to provide advice on litigation funding, and a new bill was introduced, the Litigation Funding Agreements Enforceability Bill. That would have reversed PACCAR by clarifying that third-party funding agreements didn't fall within the scope of the regulation. Unfortunately, that bill didn't survive the 2024 election. It wasn't passed in the wash-up, so it's fallen by the wayside. The current government has indicated that it doesn't intend to reintroduce that bill. It can waiting for the CJC to report. The CJC has now reported in June 2025 and has recommended that PACCAR is reversed with retrospective effect and deals with a host of other issues. And the latest word is from just before Christmas. Rachael alluded to this, the comment from Sarah Sackman and the government's press release. So we know now that the government intends to reverse PACCAR. We don't know precisely how they intend to do it. We don't know whether it will have retrospective effect. And the government's also promised proportionate regulation. So we do appear to be moving away from the self-regulated model somewhat. But it remains to be seen what that's going to look like. And finally, because we are at an SLLC event, I did want to touch briefly on what third-party funding has to do with maritime arbitration. So I put two quotations on the slide. The first is from the latest edition of London Maritime Arbitration. Third-party funding has yet to make any real impact on London Maritime, analogous to that of third-party funders, and should therefore be subject to the same regulatory framework. And taking perhaps a divergent view, the latest ICA in arbitration, I think, which is from 2018, entirely carves out maritime arbitration from the scope of its recommendations. So an interesting divergence there. I think there's more to be said for the ICA view personally. I mean, FD&D clubs, in my view, are essentially mutual, a long history. And there are a number of salient differences between one FD&D cover is discretionary. FD&D coverage tends to involve a much higher degree of control by those who are managing the litigation than might be thought appropriate in the context of third-party funding, and control is something Julian will touch on. And they're usually subject, depending on the club's rules, to a pay when paid provision. So they're not really a direct method of financing at all. They are indirect at best. So there are a number of salient differences, but I'd be very interested to hear what the audience has to say on that topic.
No, not at all. That was excellent. Thank you. Very interesting, Maurice. Thank you. Just before we move on, and there may be a question from your co-panelists, but with respect to the PACCAR decision, just to ask you, as you said, the respective impact and effect, and in the ministerial statement in December, CAs with prospective effect. Now, that is just a ministerial statement, but in your view, how significant is it if PACCAR is not reversed with retrospective effect?
Well, first, thank you for correcting me. I hadn't picked up on that point from Sarah Sackman's statement, but I think it is an important point, but perhaps less so now. There's been a judicial recognition that these can be revised in a way that retrospectively validates them. I mean, in the Sony and the Neil litigation, one of the provisions that was actually approved by the Court of Appeal there as well was essentially this litigation funding agreement will be based on a share of the proceeds in the event PACCAR is overturned. Alternatively, it will be based on a multiple of the funders outlay. So I think we will see more of that in terms of new agreements that are being has been sanctioned. I think it's probably less problematic than it would have been otherwise.
Yes, I mean, the fact is this is just a ministerial statement, so who knows what the legislation...
We don't know.
Yes, exactly. Any comment that Julian or Hassan would like to make? Okay, good.
Rachel, just, I mean, on the PACCAR issue, I mean, I guess one of the interesting features is there's a good deal of uncertainty about the application of PACCAR to the wide variety of arbitration disputes, and in particular, if those are non-English seated, even if they have an English governing law clause. I don't think any of us have seen any reported decisions that would shed any particular light on that. I mean, if you drill back through the Courts and Legal Services Act, there's no definition in there that deals with it either way, whether it's intended to only apply to legal proceedings, potentially a little bit surprising if that was intended to have extraterritorial effect, particularly around a concept like funding, which of course is subject to very different public policy and indeed conduct rules in countries all around the world. But as I say, it remains a little bit of a grey area right now. And indeed, many funding agreements may provide for dispute resolution clauses that themselves are subject to arbitration. And so the resolution of those funding disputes will not necessarily come into the public domain anyway.
Important point that you raise, isn't it? The scope of PACCAR, it's still something which I suppose in the arbitral sphere is still somewhat uncertain. And of course, the CJC report indicated that it was not going to recommend regulation for arbitration anyways. Step back.
Technically, we have discussed that that shouldn't affect arbitrations, technically speaking, from the wording of the CPR. But having said that, funders that I am aware of, from the day one start changing the governing law just to make sure that they don't face any disputes around that issue. Even if they're 100% sure that it shouldn't cover arbitration, still we wanted to be on the safe side and change the governing laws immediately, even if the dispute had nothing to do with the UK, it's US litigation.
And as you can tell from that, that is one of the unintended and to move away from their preferred governing law clause to sidestep that. Likewise, most of the funders with ongoing cases will have revisited that position with funded parties and will have sought to shore up any uncertainties in those agreements anyway. So you've probably got a relatively small cohort of historic funded party disputes that are in the backdrop there. I mean, it's obviously a great shame that the preceding government didn't get on and pass their bill in a more timely fashion, and we've now had to wait a little while for the current government to do so, but at least we are told it's now on the legislative agenda and will hopefully happen soon.
As Louise, you said, as the Court of Appeal has confirmed that multiples are not DBAs, that was enormously helpful for that to be decided, wasn't it, last year? Great. Well, thank you very much, Maurice. That was very interesting. So moving to our second panelist, Hassan will talk us through some of the practical aspects of funding, including how decisions are made to fund and how to...
Thank you so much. I am going to talk about actually the fun part of it, how to get money out of me. So just to give you a brief idea, the things I will be covering are my conclusion after reviewing 1,400 cases in last 7 years. I always say lawyering is a form of art, but litigation funding is kind of a science. There's a certain checklist, and as long as everything is checked, you're more likely to get funding. Having said that, I know that it's only 4% of the cases, 4 to 5% of the cases who have been put forward for funding gets funding. So it's a bit of a shame. But I always say there's a certain structure. And I start saying that because I'm a financial services provider, my priorities are quite different. Julian's, who is a legal services provider, whenever I receive a case folder, I turn it upside down and I start from the last pages, which is the predominant is what I call numbers game, damages and the budget. I mean, obviously I get a little bit of information about what's the case about, and then I directly jump into the quantum side of it, because if the numbers doesn't work for a funder, it doesn't matter how great your case is, I will not fund it, because every funder has a different economical appetite. For example, for me, for a commercial litigation or an arbitration, commercial arbitration, the case has to be over $10 million. It might sound a bit, for some shipping cases big or modest for others, but when I say this $10 million, I'm talking about the direct loss. I'm not including any loss of opportunity or what litigation funders are quite obsessed with that. This is how we build a model. The way how a funder works is we price the risk. I'm going to talk about other risk elements and how I price things. But once, let's say, I assess the risk, I create an Excel where I say, okay, here is this claim, $25 million. They're asking me $2 million as a budget, and it might last, some cases last longer than marriages, but let's say it's lasts for 4 years. Within 4 years, they're going to spend $2 million. And if case, let's say, settles or finishes within 2-3 years, this is how much I'm going to get. 2x, 3x, whatever is that pricing. But I provide that upfront. But to be able to create a really realistic model, I need to have that most conservative number. So that's the reason why we're a bit obsessed with the most conservative quantum number. And when it comes to litigation funding, it's even complicated because, specifically if you have a case against your insurer, there might be some sort of limitation on how much you might be covering. I love direct actions. I wrote my PhD on direct action. So for example, there might be some sort of like a limitation on how much you might be getting out of the P&I Club. So those sort of things that you need to take into account when you're reviewing a maritime case. Then once I'm comfortable with money and the budget, budget has to be 1 to 10, but that's it's kind of a religious thing. If you are asking for $10 million, you can only have maximum $1 million budget. If you are asking $2 million for a $10 million case, again, you might not be able to get the funding because it's too tight. The idea is when I get my returns, there's still a substantial amount of money left for the client. I wouldn't want to put myself in a situation where I wipe out the client. That's the reason why funding industry is quite sensitive about this 1 to 10 ratio. Once we get comfortable about that, then I move into enforcement and recoverability. That's the number 2 on my checklist. And I can assure you that, I review 200 cases per year, and predominantly most of the cases die because of this reason. Not the merits, but enforcement and recoverability. I usually say whenever they say, oh, it's a great case, I'm like, yes, but show me the money. Does the defendant have the money and where? Over 8 years now, I created this methodology. I borrowed it from journalism, actually. I call it 5 W's of enforcement. Who, what, where, when, and why. So I try to get my head around, first of all, who is the defendant? Especially in maritime industry, you might have, an insurance company on the other side, a multinational conglomerate or a state entity. So depending on who the defendant is, their asset types, their asset classes, or the strategies they might be deploying might change. So first, I try to understand who is the defendant. And then I move into what kind of assets do they have? some of the firms, if you're facing another shipping firm, they might only have one vessel. And if they declare bankruptcy, you have nothing left. Yes, you might have a really good claim, but at the end of the day, a judgment or an arbitration award is a really expensive, shiny piece of paper. You can just put it onto your wall if you can't enforce it. So I need to understand whether the other side has sufficient assets to at least cover a big portion of the awards or judgments. And then I move into the where it can be complicated, considering the global nature of the parties. So I'm not talking about just having assets, but these assets has to be in, I hate friendliness side of it, but I need to be familiar. If you have assets in certain jurisdiction, what is their judicial process? Am I going to be able to enforce my award or judgment in a really speedy way, or is it going to take 10 or 5 years to enforce it in that jurisdiction? Are they maybe hostile for foreign awards? I don't know. Or, to understand the tools and mechanisms available to lawyers and to any party trying to enforce their judgments. So because of that where element is important. And that's why funders usually work with investigators, asset tracers, who prepare kind of an asset mapping report telling us, yes, here is a defendant and their assets are in XYZ jurisdictions. And I go through it and I'm like, okay, there are some assets in China, India, tough. It might take a long time to enforce from there, but they have assets in France, Singapore, Australia, Hong Kong. Then I might be like, okay, let's focus on these ones. But that where element is extremely, extremely important. And then where element is quite relevant to when element, the duration. So as I said, like some jurisdictions, enforcement is quite speedy, especially if you are in Europe, you have Brussels regulation, which makes it easy, or international conventions for enforcement. Again, it just makes everything easy, but not everyone is that lucky. Sometimes you might end up in a jurisdiction where the enforcement might take many, many years. You might have spent only 3 years to arbitrate, and you now need to wait 6 years to enforce it. What does that mean for me? It's not just about inconvenience. It means my money will be stuck there. So at the end of the day, my responsibility is to make money for my investors. And when I make an investment, I need to be able to understand when I might be getting back my money, i.e. when we are going to be able to enforce. And because of that, I always say, the case or arbitrations process is fine, but where the real war is happening is the enforcement stage. So that's the question I always ask the lawyers. Please explain to me what is your enforcement strategy, way before explaining to me how beautiful your case is. And because if it's going to last long, then I might price it differently. And then the why elements. This is a bit of a strange one because it depends on who you are facing. So especially I have this experience with sovereign entities where you may not have sufficient enough assets, but they might have this specific ship carrying specific cargo, which is quite important for the sovereign. And if you seize that, it might irritate them and bring them on to settlement discussions. Enforcement means things. It's not just finding the biggest, chunkiest asset, but it's also being practical and, finding the right. Once I feel comfortable about all these, it took half of my time, but only then, that's how I call it ugly truth. That's how shows we have completely different mentality. I start with numbers and then I go to the money. Where is it? Now I just come to the part where I actually analyze your case. It's quite usual thing. As any other lawyer, we just look into strengths and weaknesses of the case. But I think the first starting point is the jurisdiction. Again, funding is all about certainty and being able to understand wherever you end up legally, you need to have comfort on that jurisdiction. And because of that, it is well developed in certain jurisdictions like US and UK. But there are other jurisdictions where you can see are actively funding over 250 cases. And probably 40%, a little bit under 40% of these cases are based in US. a little bit under 40% is based in the UK, and remaining 20 is based on Europe, predominantly Singapore, Australia, and Canada. And the reason why this is divided like this is because, still US, UK market, and Europe after that, and Singapore and Australia, they are the leading jurisdictions for funding. I mean, Julian will be covering the most important bits of it about how our relationship works once you get my money. And most of these things we have now more clear. We have more, I mean, even though we have still some ongoing disputes, we have better understanding of funding, how the funding market works. And I think, especially in 2026, we have more sophisticated questions to deal with, like disclosure and stuff, rather than now discussing, oh, is it legal or not? These sort of things. So jurisdiction is extremely important because of that. That's my starting point. When it comes to what does that mean in terms of shipping cases? As a shipping law nerd many years ago, I know how complicated the jurisdiction question itself when it comes to shipping, because you might have a charter party, sub-charter party, the bills of lading, and the incorporation rules are not that clear. There are really well-written books about how to incorporate jurisdiction clauses and whether your arbitration clauses are incorporated from your charter party to your bills of lading. But still, there are times where lawyers might leave the dispute resolution clauses at the end, and they might be a bit of sleepy and drafted in a way that it might be really vague. So what does that mean? Just to give a real life experience, once I had this absolutely amazing case, I was 100%, I mean not 100, but 75% sure they're going to win. But the jurisdiction clause was terribly drafted. Only two options we had of jurisdiction where the case might have taken over 15 years, or in England. I was like the two extremes. And we tried to get more clarity on that. But unfortunately, the case died. I mean, I passed on the case because of this uncertainty, because I wouldn't want to risk ending up in a jurisdiction where we may not have certainty around that legal issue. Again, a practical experience, a practical example of how jurisdictions, I mean, direct actions is an area that I felt passionately about and wrote my PhD for 4 years. It was really interesting. Every jurisdiction has a different approach. Some jurisdictions, they are more insurer friendly. Others, they're more, let's protect the weaker party. And which means that whenever you try to rely on the dispute resolution clause on your P&I insurance, they might say, jurisdiction clauses on your P&I insurance policy is not binding on this particular weaker party, so you need to sue them, or like they can sue you in their own jurisdiction. What does that mean is, if there's sort of jurisdictional ambiguity, or we mentioned on pay to be paid clauses, these sort of things, again, creature of English law, you might not find it. English law is quite liberal on that one, but in European courts like Finland or Turkey, they might be really protective and strict on those. Again, they end up giving you two opposite results. So you need to know where you're going to end up and what would be the governing law. Once I get my head around on jurisdiction and governing law, then I move into my fourth criteria, which is the parties involved. I mean, usually it might come across like, it's quite straightforward. Every law firm does their due diligence on their clients. Yes, but, still it's slightly more important in a funding perspective, in a way that we are regulated by SEC and, financial institutions. So there are certain things that we might check in terms of KYC checks. So we look at both client and claimant and the defendant. For claimant, I think, especially in shipping industry, it's really important to check whether they're sanctioned or not, because again, it's a big discussion in the shipping world. I'm aware of, and that's the reason why we try to make sure that we don't fund or involved in these sort of issues. And in fact, some funders, they more have like a blanket. They say we don't do any cases against or for them. So it's important to understand the appetite of funder on that regards. And the defendant, as I said, it's highly linked to my enforcement bits. You need to understand where they're creditworthy, whether they have money, or their identity might affect the way how you might be dealing with them. And then my last criteria is the legal team. I always say I would rather fund a great lawyer with a moderate case than a moderate lawyer with a great case, because it's at the end of the day, law is an art in that sense. And this dispute lawyer, you need to trust their abilities to bring the case to the finishing line. So I realize that it's the end of my time. If you follow this checklist, I assure you that you are more likely to get funding, or at least you're likely to get a speedy no. So time is everything.
Thank you, Hassan. Fascinating, the practicalities. Any comments from most?
I have one question. You mentioned, Hassan, your 1-to-10 ratio.
Yes.
That you adopt to make sure clients don't lose out on it. Is that driven by a concern about enforceability? Or?
That's a really lovely question. I don't think so. Might be now we have more question marks around enforceability of LFAs, but I think it's more sophisticated concern. Initially, I think it started because of not wanted to look like a funder who wipes out everything. Because yes, we might not see that client again, but we will definitely see that lawyer. And we wouldn't want to have that sort of a reputation in the market where, we have this sort of brutal pricing structure. And at the end of the day, it's a free market, unlike what people think. We compete with other funders. And the essence of that 1-to-10 ratio comes from like making sure that we don't end up that kind of an ugly situation, which is likely to end up in financial.
Rachel, yeah, I mean, just on the practical side of funding, just a few snippets from me from the other side of the fence, acting for funded parties, just to share a few points, I guess, would be, first off, the question for your client is who's actually going to advise them on choosing a funder who might back their case, and then subsequently the terms of that funding, both headline key terms, key commercials, but also the 40-odd pages of technicality in the funding agreement, which will go to some issues that I'm going to touch on in my talk, like funder control. That's a pretty detailed exercise. If we're talking about disputes over 10 million, which we usually are in the world of funding, and I agree with Hassan on that, your client's going to have a lot of money at stake on that particular decision. So you're going to send them off to a broker, but bear in mind, in my experience, certainly, funding brokers typically will help you broker the deal and find you a funder, but they will not be advising you and your client on the terms of the funding agreement in any great detail, nor are they, in this capacity, a fully regulated profession. Even if they are insurance brokers when they're selling you insurance, which some are, when they're assisting you with funding brokerage, that is not regulated in the same way. So you need to have a think through a few of those questions, because my concern is sometimes clients fall through the gaps on that and they end up not really getting the advice they need on what are very detailed agreements that have big financial ramifications for them. There are quite a few funders out there to choose from if you've got the right case that ticks all of Hassan's boxes. And so taking some time with your client to get that right is really important.
Great. Well, now we turn to your character of litigation, arbitration, control, funder control, that sort of thing. So lead off. Thank you.
Thank you, Rachel. Swivel round. So thank you very much. I'm going to be covering off 3 themes in this presentation. Firstly, disclosure of details of third-party funding, who's the funder, should any details of the agreement be disclosed. Then the level of involvement of the funder in the conduct of proceedings, and then finally, impact of funding on cost orders that can be made usually at the back end of the proceeding. Arbitration and litigation. I'm not going to be covering class actions because they are a very different beast and bring into play some very different policy reasons and indeed law in relation to funding in particular. So moving on, theme 1, disclosure of third-party funding arrangements, and starting in the world of arbitration. Mandatory disclosure is increasingly the case in many of the major arbitral rules to ensure transparency. One of the primary purposes there is to avoid conflicts of interest between arbitrators and funders in arbitration proceedings. This is a point that's quite neatly explained in the very good Chartered Institute of Arbitrator third-party funding guidelines from late last year. And if you're interested in the funding of arbitration, I thoroughly recommend you have a look at those guidelines because they've got all sorts of useful information. As in the quote up on screen there, the most obvious example is that potential conflict between the arbitrator actually having a financial stake in the funding entity. Of course, that's scenario, but one, in my view, that shouldn't really cause anyone any great problems is where the funder is funding other claims in which the arbitrator and all their law firm serve as counsel. To my view, that wouldn't ordinarily raise a conflict, but it is one that is from time to time being questioned. So looking across at some examples of institutional rules that mandate disclosure, starting in Singapore, there you have the classic provision of disclosure of the existence and identity of any third-party funding agreements at the notice of response stage or as soon as is practicable. But the tribunal can go further, which could go to the details of the funder's interest in the outcome of the proceedings. Then if we look further afield, ICC is mainly focused around existence and identity of any non-party with an economic interest. ICSID, again, name and address of persons or entities that control or own the funder. And that's quite an interesting one. You see some of that language, we'll come to it in the CJC recommendation, because it appears to say we don't just want to know who the funder is, we want to know who's provided the funds to the funder, who are the investors in the fund. Then in Hong Kong, again, it's simpler facts of the funding agreement and the funder. So we've got a fairly common pattern there over existence and identity of funding agreement and funders, but disclosure of the full funding agreement is not usually required unless there's a very specific reason. One of those reasons could be security for costs, and we'll get into that a little bit later. In terms of timing, ordinarily that should be as soon as is possible to facilitate transparency and notably to avoid that remote risk of a conflict with the arbitrator, albeit there are some cases, and again, we'll touch upon those where actually the disclosure has come much later and it hasn't transpired to be a big problem. Ramifications of disclosure. Well, here, actually, I'm touching on the slide a quote from Professor Mulheron in her seminal report for the Legal Services Board. And there can be a few ramifications. So firstly, it could trigger a security for costs application. Secondly, could trigger an application for disclosure of the full funding agreement. Although, as I've commented, actually getting that disclosure, I would say, recusal of the arbitrator. And any one of those applications, of course, can create additional legal costs and can cause some delays to the process. So if you can avoid them, then it is best to do that. Then looking across to the equivalent position in litigation, commercial litigation in England and Wales, well, Moens has already talked about the fact we don't yet have regulation of funding. We've got a self-regulated litigation market. Generally, disclosure of third-party funding arrangements is not required. There are some very specific rules in CAT opt-out claims, but as I commented, I'm not going to be talking about class actions here. But then there are some other scenarios, and again, it's security for costs, non-party cost orders that can require a little bit further disclosure. And then looking forwards to where we're going in litigation in England and Wales, well, you've already heard and no doubt knew anyway. Last year, the Civil Justice significant report on third-party funding, and one of their many recommendations was for mandatory disclosure of the fact of litigation funding, name of the funder, and the ultimate source of funding. And that issue about ultimate source of funding, I think when we get on to actually the drafting of any litigation funding regulations, that's one of the points which will need to be looked at carefully, because I know from discussions with many funders that will be a significant sensitivity for a number of their investors. And they will be saying, look, if we had to disclose all of our investor names, you'd destroy the market. So that some caution is needed there. In the response from my firm to the preceding consultation, I mean, our stance was that there's no adequate reason that I can see from policy parties should be required to disclose to the court and the other parties they're being funded. And we drew the analogy with the insurance position where, you know, in reality, why should it be considered any different from insurance where classically you wouldn't be obliged to disclose either legal expense insurance, or certainly not post-LASPO, or indeed underlying liability or indemnity insurance. And to treat parties differently in this regard as to how they're funded or insured, to my mind, just seems unjustified. It wouldn't create air. So whether you favour more disclosure or less disclosure, my main point would be there should be a level playing field. Looking across to Europe, again, there's not any formal EU-wide system of regulation of litigation funding, nor requirements across Europe for disclosure. That's dealt with country to country. It did look like Europe was heading that way, though. In 2022, following the Voss report, the European Parliament indicated they were moving towards light touch regulation, including existence and identity of funding. However, late last year, European Commission announced they weren't going to be taking that forward. So it would appear that particular debate has stalled in Europe for now. Also last year, and another good one for your reading list if you are interested to learn more about this, is the European Law Institute, ELI Principles, third-party funding, lots of great information in there. It's effectively a set of recommendations for lawmakers and courts. It doesn't have any binding effect on any of those courts, but it pulls together an awful lot of wisdom and knowledge around funding issues. And the ELI principles were in favour of early disclosure of funder identity, just identity, to courts and litigation parties. So moving on to my theme 2, funder involvement in the conduct of proceedings. Well, I'll skip over the history. Moaz has already taken you through this, the historic prohibition on maintenance and champity, but then during the 2000s in particular, increasing judicial acceptance of the role of litigation funding. That acceptance was further endorsed by Lord Justice Jackson in his 2010 review of civil litigation costs, which then led to LASPO. And he also took the view that the industry was still quite fledgling, and so it was too early to contemplate regulation at that stage. We then have the ALF code, self-regulatory code, which at 9.3 sets out a funder will not seek to influence the funded party's solicitor or barrister to cede control or conduct of the dispute to the funder. And also the observation that in over 20 years of litigation funding in English litigation, no commercial funder has yet been found to have breached the doctrines of maintenance and champity, albeit when it comes on to some of the cost cases I touch upon, there have been some indications some funders have from time to time perhaps gone a little bit further in the control sphere than the court's happy with. So CJC report again, and looking forward, we've got a recommendation for prohibition on litigation funder control, either direct or indirect. Interesting how we're going to interpret indirect control, including settlement and settlement negotiations. I think that patently is one of the key areas where people need to be careful, whether they are the funder themselves or a funded party or the funded party's lawyer, to look at that carefully. One of the potential real kind of teeth in all of this, of the new legal litigation funding regulations when they come, would actually result in unenforceability, albeit with the suggestion that won't be quite as draconian as under the much criticised DBA regulations, and there will be some escape clauses for funders to try and prove that, notwithstanding they may have breached the regulations, there's no harm done, in essence. I think we've also already mentioned the recent ministerial December 2025. So plan to introduce proportionate regulation of litigation funding agreements to improve transparency and fairness for claimants, to be introduced when parliamentary time allows. Great phrase that, isn't it? So who knows when that's coming, but sometime. My take, as I've already alluded to, is there's going to need to be a further consultation getting into the weeds of the litigation funding regulations. I'm going to be interested for your thoughts on that, Rachel, particularly if we are going to say, get it wrong and you've got an unenforceable agreement, it's really important to get it right. Then I mean, there's some commonalities between litigation and arbitration on what's permitted. I think the vast majority of commercial funders in the market do play a hands-off role. They, they of course want to monitor disputes. They expect a monthly report from you as your case goes on. They want to conduct their ongoing due diligence. They've obviously got a duty to their investors to manage the investment, but they're not looking to manage the court or arbitral proceedings on a day-to-day basis. They are going to be interested if there are strategic decisions or twists and turns in the case that are going to affect the funding budget or indeed the funding timescale, as Hassan's made clear there. That's a big issue. The courts have acknowledged funders, many funders, have an official role supporting the litigation team. And there have been one or two cases, again, where courts have, rather than criticising funders for control, have actually said the opposite and sort of said, well, the funders should have taken greater care before funding things that the court view maybe was getting out of control. Actually, in the agreement, patently, those agreements should be well drafted and should clearly specify what degree of control the funders actually seek to exert. In some funding agreements, but not all, they may ask, they may have a contractual right to attend key meetings, for instance, consultation with counsel or experts would be an example. Potentially more contentious is rights around settlement agreements, as I've talked about, particularly this one about, do they have the right to actually come to a settlement meeting or even veto settlement offers? So that's where things start to get into the more contentious terrain, I think, of funder control. In arbitration, arguably, funders could influence a bit more arbitration, a bit more control due to differing legal limits and the less public nature of the proceedings, albeit that's not been my firm's experience of funded arbitration. Point I make here, though, particularly once you're into international arbitration, is the agreements are going to need to comply with applicable law and arbitration seat laws, and also the lawyers for the funded parties are going to need to be careful to ensure they're complying with their own rules of professional conduct. So a few things to have a think about there. Then an observation really that the degree of funder control can vary massively from funder to funder and across jurisdictions. And the adoption of restrictions on funder involvement in proceedings and I guess or things like PACCAR does influence how funders view the jurisdictions and whether they've got appetite to invest in those jurisdictions at all. And a PEO of Litigation Capital Management, LCM, which coincided with them effectively announcing they were transitioning to a runoff model for existing investments. And it included a kind of lament from the CEO of this funder of having shifted to a lawyer-led approach to managing its funded cases and reflecting on really what he wanted to do was to get back to what he'd been able to do in Australia, which is have this much more active investment management approach, much more about the money, less about the case, less about what the lawyers may think about the case. So that was one of the more telling public statements, I think. But I don't want you to think that is typical of funders. I mean, I was quite surprised when I read that statement, and I think it is. I would view it as more of an outlier statement. Then we turn to impact of funding on cost orders, costs in court proceedings. Well, the courts have got a discretion as to who pays costs and can make an order against a non-party, including a funder, under Section 51. If they're going to do that, they should add the funder as a party under CPR 46.2, so the funder's got the opportunity to attend any hearing relating to any such order. Funders can be liable for an indemnity-based cost order against the funded litigant, even if the funder themselves has not demonstrated any conduct that would warrant an indemnity costs order. And that comes from Excalibur. Arkin, we've talked about, and I think you all know about. We've also talked about the relaxation of the Arkin cap more recently. And I pick out a couple of cases there. The Chapelgate case, where the courts indicated there were a wider range of factors, for instance, with ATE, were they funding all of the case or part of the case? And I'm not wholly convinced with the reasoning about what their returns are affecting what their liability for a non-party cost order should be, but one to be probably dealt with on another occasion. And then, as I mentioned, Laser Trust is an example of where the court felt the funders were perhaps, it'd be a reason for making them liable for costs beyond the Arkin cap. If we come back into the contractual liability position between funder and funder party in the funding agreement, first off, funders can, but don't have to, provide an indemnity for opponents' costs in unsuccessful litigation in funding agreements. In my experience, funders almost always require the funded party to take out AT insurance or require for it to be taken out by the funder on their own behalf. So there's nearly always that insurance layer these days. Some funding agreements require the funded party to indemnify the funder. So if the funder is subject to a non-party costs order, they can, in contractual terms, still try and get their money back, which is another reason why AT is important. And because of that, I think it really is important that funded parties get some input from an experienced insurance broker on the pros and cons, including in whose name is that policy taken out? Is it the funded party or is it the funder? Who's got direct rights to claim on that policy? So security for costs in litigation, well, presence of third-party funding can influence security for costs applications in the courts, but the increasingly common remedy for providing security rather than the funder putting up the money themselves is AT insurance backed by anti-avoidance endorsements in virtually every funded case I've been involved in recent times. That has been the way security has been dealt with. It's most efficient, I would say, avoids the need for the funders to ring fence capital or indeed the funding party to do that themselves. So it's just more cost effective. And the courts are pretty accepting of that, as long as the wording of those AAEs is correct. But good insurance brokers will help you with that. Arbitral tribunals generally cannot order costs directly against funders, as they're not party to the funding agreements. But funders can support parties in arbitration, either by an indemnity in the funding agreement or by providing the money to pay a premium to get an ATE insurance policy. Security for costs in arbitration is, I'm told by those who regularly practice in arbitration, a more recent phenomenon compared to court proceedings. And arbitrators are meant to avoid prejudging the merits on those applications. And the simple fact of funding shouldn't really determine that application either way, vis-a-vis case merit or the perceived financial weakness of a funded party. And on that, of course, many people choose to go for funding, even if they theoretically could fund the case themselves. For many companies, that's just a good way to balance their corporate sheet, corporate balance sheet. Then finally, I wanted to touch upon recovery of third-party funding costs, because I think this is a pretty interesting area where actually arbitration has potentially led the way, because following the ESAR case in 2016, we actually saw a successful party recover their third-party funding costs, providing the arbitrator thought they were reasonable and justified. Timely disclosure, which we've already talked about, albeit in the second case I mentioned on the slide, Tenke Fungarumbe versus Katanga. In fact, that disclosure only came much later, but yet the arbitrator still allowed a recovery of funded costs. And it will be interesting to see how much further track loss at litigation. Generally, that's a bit of a no-no. Third-party funding costs generally not recoverable in English court proceedings, don't fall within CPR 44. The CJC looked at this issue as part of their report and recommended a very limited exceptional circumstances recoverability provision based on conduct, necessity, claimant financial position. I think they were motivated by the true David and Goliath situation. Bates versus Post Office very much in their mind. But there are some cautionary lessons that can be learned from the CFA wars that preceded LASPO, which of course, resulted in the end of recoverability of success fees and ATE premiums. So I think there's a note of caution there that blanket recoverability, it really is a double-edged sword. So some recoverability for ensuring weaker parties can retain more of their compensation, but it needs to be moderated and done in a fair way. It's me done.
Thank you, Julian. Covered an enormous range of ground there. And so perhaps a discretion on the part of the court, anything mandated in the regulations to come might be the way forward, perhaps.
Yeah, I think it's going to be a really interesting area. Again, a point that both the CPRC will need to look at, and indeed the, any further consultation around litigation funding regulations. Form of recovery of funding costs would be a good thing. The proposal I put to the CJC was that it be tied into Part 36 offers. So if a funded claimant put forward a reasonable Part 36 offer that was not then bettered, that could be a gateway to them recovering some of their funded costs, but maybe still kind of capped to avoid that, which may also overcome thorny issues about disclosure of the terms of funding. Of course, the defendant might say, well, I need to know what I'm in for here. Is it a 3x? Is it a 4x? What is it?
That concludes the panel. So over to the audience for any questions, comments, feedback on your own views. Feel free. And please, if you could identify where you're from as you ask give your comment. Thank you.
I have a question up my sleeve, but the question I want to ask at the moment is for Hassan, please. Given that you can get an adverse court order against a funder direct in court, but you can't in arbitration, does that make a difference to your willingness to fund a case according to whether it's in court or in arbitration? Or is that something that doesn't matter?
And that's definitely a risk that we think of. But in terms of when it comes to saying a yes or no, not that much. I mean, we just make sure that there are contractual mechanisms in place and we take that risk into account when we dedicate a certain budget to our investments. So,
thank you. James Clancy, arbitrator. Just quickly by way of background, I was a member of the ICA Queen Mary task force, so I am able to insight into the carve-out for maritime arbitration. It came really from a conclusion of the co-chairs of the task force that it was inconvenient for them to hear about the defence clubs, which did not suffer from a duty of disclosure of funding in arbitrations, and which had rules permitting them to exercise, if they chose, quite a high degree of control over the conduct of the arbitration, including, importantly, choosing the lawyers. So maritime arbitration was carved out from the recommendations that the task force made. I tried to legislatures and institutions do not make those distinctions. The answer includes maritime arbitration and the definition of international commercial arbitration. So it's unworkable, as is, by the way, the definition of third-party funding in the ICA Queen Mary report. I don't recommend it. It's not a good read, but I'm afraid to say that it includes BTE, before the event insurance, in the definition of third-party funding. So the BTE insurance would have to be disclosed. But then the carve-out is given for maritime arbitration to keep the maritime lawyers quiet. But it's ludicrous. It isn't the level playing field at all. What was inconvenient was the idea that defence clubs were successful without being regulated. That was unacceptable for the co-chairs of the task force. They had to make recommendations. I was a semi-detached member. Given the success of some degree of control in the conduct of arbitration, and given the clear words of the Court of Appeal in Excalibur Ventures that it is a duty of the funder to take rigorous steps short of champity, why is it that the Association of Litigation Funders hasn't updated its code of ethics to bring it more in line with the practices in maritime arbitration and actually have a positive duty on funders, not just to monitor, but to take rigorous steps?
I mean, perhaps I can start. I mean, it's a very helpful background. I mean, when I read the ICCA report, it really treats maritime arbitration sort of sui generis and says, well, it's all very self-contained, and there's a lot of internal policies and norms that. On your second point, it's actually relevant to a question I was going to put to Julia and Hassan. So if I may, I mean, the point about control is a very interesting one, and it seems to be much less about enforceability now, given what you say about Excalibur and the expectation really that a prudent funder should be intervening, at least to the extent of subjecting the analysis to rigor, reviewing at regular intervals and so on. So it seems to be much less about enforceability. Although, as Julian touched, you have a recent case, Laser Trust, which really points to control as an indicator of when you might blow through the Arkin cap. So I'm wondering how you square that circle, and maybe that's, I don't know, extent of control and where you draw the line in terms of minimizing your costs. Julian, Hassan might have some thoughts on that.
Do you want me to go, Hassan? I mean, the extent of the funder's cost exposure, come back to my point, by and large, funders protect themselves with AT insurance. And so they're very careful to make sure there are appropriate levels of AT insurance in place. But having done that, the risk of being exposed to a non-party cost order is viewed by most funders in most cases. There will, of course, exceptions to that. I think the issue of funder control is a much more sensitive issue. It has been, a significant feature in some quite kind of polar lobbying in relation to litigation funding in the UK, in Europe, and in the US, where those opposed to litigation funding, largely very big kind of commercial chambers of commerce and such like, of representing, big business, would use the argument of funder control to try and seek to limit funding or impose greater degree, and hence making it less likely claims will be funded and brought against them. So you've got that counter argument. I think most of the funders have themselves been appropriately cautious about funder control. They obviously do, keep away from trying to tell the lawyers what to do, or actually tell funded parties, you must do X or Y, or accept this offer, or make this offer. They may express a view, but not go as far as to say, and if you don't do that, there's going to be trouble.
I'm going to be the black sheep of this industry, but I think some funders can be quite straightforward about their opinions. So that's the reason why it's really important to make sure that you understand the way how they operate, in terms of they might not call it control, but they might have heavy duties of reporting, which includes getting some feedbacks about your submissions. As a lawyer, you live and breathe with that case for 20 next to my 200, 300 other cases. So probably you have already thought about that. But having that kind of a ping pong with the funder might be time consuming. So that's why someone quoted me once saying, "Oh, Hassan suggests you to work with all the funders." Yes, I do. Go work with all the funders, but to understand what works best for you, because sometimes a lawyer might prefer having that kind of a safe hedge, someone telling them, "Did you consider X, Y, Z?" Or someone else with experience of 25 years, they might be saying like, "Yeah, when you were in elementary school, I was doing the same cases, so go away." So that's the reason why I start saying I'm a financial services provider. Yes, I do have a PhD in law, but I'm not a legal services provider. But sometimes people might forget this reality. I'm all for funding, but it's important to remind that. And the only time I think the active involvement of funder is doing preparation for settlement in a way that I was talking about this Excel that I give to lawyers and the client, which shows you how much money you're going to actually get if you settle at a certain amount within a certain period of time. And I think getting that sort of a financial mathematical exercise from a funder might be helpful for a client to make an educated decision, but that decision must be the client's, not funders, not lawyers, the clients. But we know from Financial Times that might not be the case all the time. So just bear in mind.
No, I agree, Hassan. And I mean, we mustn't lose sight of, the primary responsibilities each have. The funder's primary responsibility is going to be to his investors and to try and get a good return for them. Meanwhile, the lawyer representing the funded party has the professional duty to the funded party, not to the funder, even if the funder are paying them for the work that they're doing. And so you've got to keep those boundaries very clear.
Yeah, that's the reason why you said like that contractual relationship, the LFA is the key document, not just for this sort of a disagreement, but the lawyer and the client might have a disagreement on a settlement discussion. What's going to happen then? Like even that kind of a scenario might seem like not happening quite rare, but it happens all the time. The lawyer says, this is the most commercial, best settlement in my professional opinion. And the client might say, no, I'm going to go for the whole full award. And in that scenario, you still must have a contractual provision in your LFA telling how funders can react to even these sort of conflicts. So sometimes the lines might not quite clear in that sense. Funders will hate me.
Any other questions from the floor? We have time for a couple more, and I'll just check online whether we might be able to get a question. Yes, please go ahead.
Firstly, thank you to the panelists. My question's a relatively short one. I've seen funders step in and purchase claims and take an assignment in an insolvency context. I haven't seen it in any other context. Is there a reason for that? Is it just the money doesn't work for most funders on those sort of claims? They don't want to take an assignment, or is it is there some other reason I'm not aware of?
Oh. I mean, monetization, actually, we were talking about this, the hot topic of last 2 years probably, but in this quarter, I've been receiving a lot more inquiries about monetization, and it happens pretty much in any context, before award, during the dispute, post-award, or same thing for litigation. It's not only in insolvency contexts, even large corporations who doesn't want to spend time, say like just buy this, investments, or, I don't want to deal with the whole process. And it became a lot more popular because of two reasons. First of all, again, probably financial turmoils in the world made people more commercially savvy in a way that even big corporations in these days, they try to make sure that, they can utilize funding options, and, they might be going through restructuring or different investment reasons, or they might have quite entrepreneurial GC who might come up with an idea that, oh, you know what, we can actually get, our money back quite quickly, because $1 today is way more valuable than a speculative $2, $3 in the future. So because of that, I think now everybody thinks about monetization, and it became a lot more popular. I need to underline that because I was so surprised. Julian was asking me, oh, what you have been seeing in these days? I was like, within a month, probably I saw like at least 5, 6 new monetization inquiries. I think it became a lot more common now.
Just very quick question. Philip Sharanovic from Queen Mary, University of London. For Hassan, putting aside traditional funding, how else can claimants potentially benefit from funding? Can they perhaps sell their awards?
Yeah. So yeah, it's, I think, the new and trendy way, but also I think portfolio funding is another thing that big companies start using, because, for example, in terms of shipping companies or big corporations, multinational corporations, they might have multiple cases, and it might be more cost effective to get a sort of like a portfolio funding for their cases. It happens. I think I have seen it in more construction sector or energy sector than any other, but they're likely to have big awards or upcoming cases from different jurisdictions with different risk types, and they might be like, I have 5 of these cases, and would you provide funding in general for that? Or again, they might just want to sell it. Or, I mean, when it comes to monetization, I need to quickly explain that I can buy it up front and you get rid of it, and I'll deal with that. Or we can do a hybrid version where I give you an upfront payment and then fund the processes in a traditional way, like I fund a case, I fund the litigation process, and you get a back-end payments, or, that might be an option too. There are different ways to monetize. It's not just upfront payment, what we can come up with different ways, because when you monetize, the market is around 7 to 10%. I mean, there are other 10, 15% on some websites, but in reality, 7 to 10 is the general view. So a party might not want to sell it outright, but there are other ways to liquidify, getting rid of the biggest chunk of it.
Thank you. Catherine Jago from CJH Experts. I was interested to hear that liability was the last thing that you look at. Sorry, not liability, the merits of the case are the last thing you look at. Obviously, the merits of the case are made up of two elements, as far as you're concerned, the liability and quantum. Now, as an expert, I've been involved in a number of cases that have been third-party litigated and supported. Not once, as an expert that mainly deals with quantum, have we ever been asked our opinion of the validity of the quantum claim that's being made. Do you take that into account when you're deciding whether or not to third-party fund? Would you ask an expert, is this a valid claim? Because very often, if we get involved late, we look at the claim and we say, I'm sorry, this has not been either calculated correctly or there's no way you can make this quantum claim.
Definitely. That's the reason why I start with numbers. And I always say that engage with an expert as soon as possible, because that's the only way to expedite your funding process, because we need to understand not just numbers, but are they valid? I have seen lawyers trying to work their ways around numbers, and they are not well known for their mathematical skills.
And jumping in on that point, I would say in terms of presentation of your case to a funder, if you want to secure funding, and most funders turn down far more cases than they ever take on, this is a key part of good preparation. So certainly my firm, in any case with any complex quantum, will have wanted to have done our homework with our experts in advance of even going to the funder, to at least have an outlined theory of the economic losses. Because as you say, if that's all going to unravel later on and the case that was meant to be worth 100 million is only worth 8 million, then it's not been an economic prospect for anyone. And
even then, I do my due diligence and I work with a quantum expert just to double check the numbers.
Is that your own quantum expert?
Yeah, I separately in my due diligence process, I work with a specialist to check the numbers I have been provided, even though they were provided by a quantum expert engaged by the lawyers, because that's the key. That's the number that I need to know for the whole thing.
Thank you.
Well, I think that time is up. And so it would be lovely to continue this discussion at thanks reception, which has very kindly been provided after this. But it's been a fascinating discussion. The 3 different perspectives has been marvellous. And I thank all the panellists, and could we please show our appreciation in the usual way.
Thank you very much, everybody, Rachael, Mo, Hassan, and Julian. I think you'll all agree with me that we absolutely picked the right panel for this topic tonight. What a fascinating session we've had. Just remains for me to thank everyone for attending. Those of you who are here at the IDRC in person, we do hope you will stay and enjoy the reception, which Stewart's and 36 Stone have kindly sponsored. Thank you all very much once again.